Hello students, I am Dr. Harpreet Kaur from Army Institute of Law. The topic for the day is freedom of speech and expression vis-a-vis social media platform and analysis. Introducing the topic, the 21st century has been called the internet age. Rightly so, as most of the work today is done with the help of internet. Especially with the COVID-19 pandemic, the internet has provided a quick and efficient platform to all people for expressing their thoughts, beliefs, words, etc. Since the 17th century, if not earlier, human thinking has been wearing round to the theory that man has certain essential, basic, natural and inalienable rights or freedom, and it is the functioning of the state in order that human liberty may be preserved, human personality developed and an effective social and democratic life promoted to recognize these rights and freedom and allow them a free play. Fundamental rights are rights having a noble pedigree. They are natural rights which are in nature of external conditions necessary for the greatest possible unfolding of the capacities of a human being. These secured and guaranteed conditions are called fundamental rights. Such rights command a higher sanctity than other rights. Example, right based on contract because they exist independent of any act. Thus, fundamental rights were deemed essential to protect the rights and liberties of the people against the encroachment of the power delegated by them to their government. They are limitations upon all powers of the government. In a leading case of Maneka Gandhi versus Union of India, 1978 Supreme Court, page number 597, Bhagwati Justice observed, these fundamental rights represent the basic value enshrined by the people of this country since the Vedic times, and they are calculated to protect the dignity of the individual and create conditions in which every human being can develop his personality to the fullest extent. They weave a pattern of guarantee on the basic structure of human beings and impose negative obligation on the state not to encroach an individual liberty in its various dimensions. Social media. Today, technology has become a boon for those who require sharing information in bulk. It primarily comprises of internet, mobile phone based tools for sharing and discussing information. Rather than the physical environment, today communication is possible through internet with the combination of internet technology and interactive tools. Such combination enables the wireless dissemination of information quickly and seamlessly. As such, social media can be defined as any web or mobile based platform that enables an individual or agency to communicate interactively and enables exchange of user generated content. Social media can be broadly classified in the following categories. First is social networking. It is an online service that enables its users to create virtual network with like-minded people. It offers facilities such as chat, instant messaging, photo sharing, video sharing, updates, etc. The most popular are Facebook and LinkedIn. Second is blogs. Blogs are descriptive content created and maintained by individual user and may contain text, photos and links to other websites. The interactive feature of the blogs is the ability of the readers to leave comments and the comment trail can be followed. Third is microblogs. Microblogs are similar to blogs with a typical restriction of 140 characters or less, which allows user to write and share the content. Twitter, now known as X, is a microblogging site that enables its user to send and read tweets. Vlogs and video sharing are blogging sites that mainly use video as the main form of content supported by text. YouTube is the world's largest video sharing site. YouTube is a video live casting and video sharing sites where users can view, upload, share videos and even leave the comment. VIS-A-VIS is a collaborative website that allows multiple users to create and update pages on particular or interlinked subjects. While a single page is referred to as wiki page, the entire related content on that topic is called as wiki. These multiple pages are linked through hyperlinks and allow the users to interact in a complex and non-linear manner. Next is social bookmarking. These services allow one to save, organize and manage links to various websites and resources around the internet. Interaction is by tagging websites and searching through websites bookmarked by other people. The most popular are Delicious and Stumble Upon. Next is social news. These services allow one to post various news items or link to outside articles. Interaction takes place by voting for the items and commenting on them. Voting is the core aspect, as the item that get the most votes are prominently displayed. The most popular are Digg, Reddit and Propeller. Next is media sharing. These services allow one to upload and share photos or videos. Interaction is by sharing and commenting on user submissions. The most popular are YouTube and Flickr. There can be overlap among the above mentioned type of social media. For instance, Facebook has microblogging feature with their status update. Also, Flickr and YouTube have comment system similar to that of blog. Now, I will be discussing with you the freedom of speech and expression. Freedom of speech and expression. Freedom of speech and expression is broadly understood as the notion that every person has the natural right to freely express themselves through any media and frontier without outside interference, such as censorship, and without fear of reprisal, such as threat and persecutions. Freedom of expression is the complex right. This is because freedom of expression is not absolute and carries with it special duties and responsibilities. Therefore, it may be subject to certain restrictions provided by law. The term freedom of expression itself had existed since ancient times, dating back at least to the Greek Athenian era, more than 2400 years ago. The following are some of the most commonly agreed upon definitions of freedom of expression that are considered as valid international standards. Everyone has the right to freedom of opinion and expression. This right includes freedom to hold opinion without interference and to seek, receive and impart information and ideas through any media and regardless of frontiers. Article 19 of the Universal Declaration of Human Rights 1948. Everyone shall have the right to hold opinions without interference. Everyone shall have the right to freedom of expression. This right shall include freedom to seek, receive and impart information and ideas of all kinds, regardless of frontiers, either orally, in writing or in print, in the form of art or through any other media of his choice, given under Article 19 Clause 2 International Covenant of Civil and Political Rights 1966. Similarly, Article 19(1)(a) of the Constitution of India also confers on the citizen of India the right to freedom of speech and expression. The freedom of speech and expression means the right to express one's convictions and opinions freely by word of mouth, writing, printing, pictures or any other mode. It also includes the right to propagate or publish the views of other people. The term freedom of speech and expression includes any act of seeking, receiving and imparting information or ideas regardless of the medium used. Coming to freedom of speech and expression and social media or internet. The internet and social media has become a vital communication tool through which individuals can exercise their right of freedom of expression and exchange information and ideas. In the past years or so, a growing movement of people around the world has been witnessed who are advocating for change, justice, equality, accountability of the powerful and respect for human rights. In such movements, the internet and social media has often played a key role by enabling people to connect and exchange information instantly and by creating a sense of solidarity. Emphasizing the importance of Internet, the UN Special Rapporteur on the promotion and protection of the right to freedom of opinion and expression in his report, which was submitted to the Human Rights Council, stated that the Internet has become a key means by which individuals can exercise their right to freedom and expression, and hence Internet access is a human right. A report further stressed that states should ensure that Internet access is maintained at all times, even during the times of political unrest. The states were also reminded of their positive obligation to promote or to facilitate the enjoyment of the right of freedom of expression and the means necessary to exercise this right, including the Internet. The states were also asked to adopt policies to make the Internet widely available, accessible and affordable to all. The UN Human Rights Committee has also tried to give practical application to freedom of opinion and expression in the radically altered media landscape, the center stage of which is occupied by the Internet and mobile communication, describing new media as a global network to exchange ideas and opinions that does not necessarily rely on traditional mass media. The committee stated that the state should take all necessary steps to foster the independence of these new media and also ensure access to them. Moreover, Article 19 of UDHR and Article 19 Clause 2 of ICCPR also provide for freedom of speech and expression even in case of Internet and social media. Thus, it is seen that freedom of speech and expression is recognized as a fundamental right in whatever medium it is exercised under the Constitution of India and other international documents. And in the light of growing use of Internet and social media as a medium of exercising this right, access to this medium has also been recognized as a fundamental human rights. Now, I will be coming to restrictions on the freedom of speech and expression. The freedom of speech and expression does not confer on the citizens right to speak or write without responsibility. As per Article 19 Clause 2 of Indian Constitution, the restriction on the freedom of speech and expression can be imposed on the following grounds. First is sovereignty and integrity of India. Second, security of the state. Third, friendly relation with the foreign countries. Next is public order. Next is decency or morality, contempt of court, defamation, and last is incitement of an offence. Coming to cyber laws in India and social media. Although there is no particular legislation which covers the leverage of opinion and expression or violation on social media, but there are certain provisions in the cyber law which can be relevant, which are listed below. First law is Information Technology Act of 2000. Under Chapter 11 of the Act, we have section 65, 66, 66A, 66C, D, E and 66F, 67, 67A and B, which contains punishment for computer related offences which can also be committed through social media, that is tampering with computer source code, committing computer related offence given under section 43, sending offensive messages through communication services, identity theft, cheating by personation, using compute resources, etc. Section 69 of the Act grants power to the central or a state government to issue directions for interception or monitoring or decryption of any information through any computer resource in the interest of sovereignty or integrity of India, defence of India, security of the state, friendly relation with foreign states, public order, for preventing incitement to commission of any cognizable offence, for investigation of any offence. Section 69A grants power to the central government to issue directions to block public access of any information through any computer resource on similar grounds. Section 69B grants power to the central government to issue directions to authorize any agency to monitor and collect traffic data or information through any computer resource for cyber security. Section 79 provides for liability of intermediary. An intermediary shall not be liable for any third party information, data or communication link made available or hosted by him in certain cases. If any intermediary fails to assist comply with direction and intentionally contravenes provisions under section 69, 69A and 69B respectively, he shall be liable to punishment. Section 43A provides that where a body corporate possessing, dealing or handling any sensitive personal data or information in a computer resource owned, controlled or operated by it is negligent in implementing and maintaining reasonable security practices and procedures, thereby causing wrongful loss or wrongful gain to any person, it shall be liable to pay damages by way of compensation to the affected person. Section 70B provides for an agency of the government to be appointed by the central government called the Indian Computer Emergency Response Team, which shall serve as the national agency for performing functions relating to cyber security. The central government has also enacted rules and timely amendments to give effect to various provisions of this Act, that includes the Information Technology, Procedure and Safeguard of Interception, Monitoring and Decryption of Information Rules 2009, the Information Technology, Procedure and Safeguard for Blocking for Access to Information by Public Rules 2009, the Information Technology, Procedure and Safeguard for Monitor and Collecting Traffic Data for Information Rules 2009, the Information Technology Intermediaries Guideline Rules 2011, the Information Technology Reasonable Security Practices and Procedure and Sensitive Personal Data or Information Rules 2011, the Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2021 is secondary or subordinate legislation that suppresses India's Intermediary Guidelines Rules 2011. The 2021 rules have stemmed from section 87 of IT Act 2000 and are a combination of the draft Intermediary Rules 2018 and the OTT Regulation and Code of Ethics for Digital Media. Now, I will be discussing with you section 66A of Information Technology Act of 2000. Of all these provisions, section 66A has been a matter of widespread discussion in the recent times. Section 66A of Information Technology Act was inserted by Information Technology Amendment Act of 2008, which provides punishment for sending offensive messages through communication channels. A glimpse into this provision clearly shows that there is an inherent inconsistency between the phraseology of section 66A and article 19(1)(a) of the Constitution, which guarantees right to freedom of speech and expression to all Indian citizens. There are several anomalies in the provision which are conflicting with the free speech requirement. In November 2012, a Delhi-based law student, Shreya Singhal, filed a public interest litigation in the Supreme Court of India. The petition challenged the constitutionality of the section, wherein she argued that section was vaguely phrased. As a result, it violated Article 14, 19(1)(a) and Article 21 of the Constitution. The PIL was accepted on 29th November 2012 and on 24th March 2015, the Supreme Court ruled that section 66A is unconstitutional in its entirety. Now, coming to the current scenario. Now, social media is playing a unique role in the functioning of democracies all over the world. Through social media and internet, citizens can unite despite territorial limitations. Although everyone is not physically present, the force of protest is not diminished in any way. Social media campaigns have bring about many positive changes in society. A recent example of productive use of
freedom of speech and expression in social media can be stated from Kerala.
A 1.5-year-old child named Muhammad was suffering from a rare disease of spinal muscular atrophy. The curative for this disease is a drug named Zolsenma, which cost 18 crore rupees. A massive campaign took place via social media to save the life of the child, and a total sum of 46 crore was collected within a week. So, social media played a crucial role in the time of natural calamities and other calamities. Social media campaigns also help in bringing about fraudulent practice in society and to curb them. In modern times, social media become a place for the voiceless to raise their voice, a place where people with similar mindset can come together and where people can effortlessly use their freedom of speech and expression. It is also important to look at the other side of the coin. It is true that social media is a platform to voice one's opinion and thought on any subject. There have been instances when social media has been lauded for playing a major role in overthrowing oppressive governments or bringing activists together for various social issues. However, if the idea of or content posted and disseminated is capable of igniting ill feelings and violence among people, it becomes exploitation of the freedom of speech and expression rather than exercising it. In such cases, social media does not actually play the role of a liberator as it ought to, but instead cause public menace. This is an issue of high relevance in a country like India, which is a combination of hundreds of languages, traditions and varied religious beliefs. Several incidents of cybercrimes, defamation, invasion of privacy, incitement of offences, racist and sexist remark, stalking, abuse, hacking, bullying, victim blaming, harassment and many more are committed through social media. Targeting a person or spreading rumors to detroit the image of a person in general public is a widespread negative trend in social media. The most vulgar form of abuse can be seen in comment section of a social media pages, and the culprit shields themselves by stating their freedom of speech and expression. Many have lost their harmonious and peaceful life due to attack of these faceless people. Toxic influencers spreading fake news, stereotypes, racism and misogynism in society is a problem to be addressed. Social media posts have triggered communal violence and mob lynching in many parts of country. Investigations revealed that hate contents circulated on social media has sparked communal riots in Muzaffarnagar. Two YouTubers who are brothers were arrested in Kerala recently for causing ruckus in government office with the support of the followers and have registered cases against other two who had called for a riots through social media following the arrest of the brothers. All these incidents highlight that it is high time to frame social media regulation without hindering the basic right to freedom of speech and expression. Coming to balancing freedom of expression and harmful speech. Balancing freedom of expression and the need to combat harmful speech is crucial. Here are some key considerations in balancing the freedom of expression and harmful speech. First is legal framework and restrictions. Legal frameworks including national constitutions, human rights conventions and local laws define the boundaries within which freedom of expression operates. These restrictions are typically aimed at protecting public order, national security, the rights and reputation of others and preventing harm. Clear definition and standards. One of the challenge in balancing the freedom of expression and harmful speech lies in defining and interpreting what constitutes harmful content. It is crucial to establish clear standards and guidelines that provide clarity on the types of speech that are considered harmful and warrant intervention. Contextual evaluation. Context plays a vital role in determining the potential harm caused by speech, the intention behind the speech, its social and cultural context and the potential impact on individuals or marginalized group must be carefully considered. Contextual evaluation helps distinguish between legitimate expression of opinion and speech that incites violence, promote hate or target individuals or communities. Next is proportionality and consistency. Ensuring proportionate responses to harmful speech is crucial. The severity of the harm caused, the intent of the speaker and the potential impact on society should be taken into account when determining appropriate measures. Responses to harmful speech should be consistent and applied uniformly to avoid allegations of bias or unfair treatment. Finding the right balance between freedom of expression and harmful speech on social media platform is an ongoing challenge. It requires continuous evaluation, refinement of policies and practice, and an understanding that the digital landscape is constantly evolving. Now, I will be discussing the challenges of content moderation. Content moderation on social media platform poses several challenges due to scale, diversity, and constantly evolving nature of user generated content. Here are some key challenges faced in content moderation. First is volume and speed. Social media platforms receive an enormous volume of user generated content every second. Moderating this massive amount of content within a short time frame is a significant challenge. The speed at which the content is shared and spread on social media requires platform to employ efficient systems and technologies to identify and moderate harmful or objectionable content promptly. Second is contextual nuances. Content moderation becomes challenging due to the need to understand and interpret the contextual nuances of user generated content. Differentiating between legitimate expression and harmful speech requires considering the specific content, intent, cultural factors and local sensitivities. The lack of contextual understanding can lead to the misinterpretation or wrongful removal of content. Third is varying legal and cultural standards. Social media platforms operate globally, but legal standards and cultural norms differ across jurisdictions. Compliance with diverse legal frameworks and strike the right balance between cultural sensibilities poses a challenge. Platform must navigate these variations to ensure consistent and fair content moderation practices. Fourth is automation and human review. To cope with the volume of content, platforms often rely on automated systems for content moderation. However, relying solely on automation can lead to errors, false positivities and removal of legitimate content. Striking the right balance between automated system and human review is crucial to ensure accurate and context sensitive content moderation. Now, I will be discussing with you some case laws regarding this. Some of the case laws that provide important legal precedent and interpretation in the context of social media and freedom of speech in India include: first case is Indian National Congress versus Union of India 2014 Supreme Court cases, page number 1. In this case, the Supreme Court held the validity of section 66A but clarified its interpretation. The court held that online speech could only be restricted if it posed an actual threat to the public order or had the potential to incite violence. It emphasized the importance of striking a balance between free speech and maintaining public order. Next case is Kamlesh versus Union of India 2015 Supreme Court cases 701. This case dealt with the issue of blocking website hosting objectionable content, particularly child pornography. The Supreme Court held that intermediaries like social media platforms have a responsibility to proactively identify and block access to such content to protect children from exploitation. The next leading case is Fahima Shirin RK versus State of Kerala. This is the latest case of 2019, page number 5 to 9. The Kerala High Court ruled in this case that freedom of choice and expression of an individual cannot be curtailed merely based on the objections raised by others on social media. It emphasized the importance of allowing individuals to express their opinions freely without fear of retaliation or censorship. The next leading case is Maheshwari versus Union of India 2020 Supreme Court cases, page number 1223. This case involved a plea seeking quashing of an FIR filed against a social media user for allegedly posting objectionable content. The Supreme Court emphasized that social media users cannot be liable for mere forwarding or sharing of content unless there is a clear intent to promote hate speech or incite violence. Now, concluding my topic, in conclusion I can say social media is a powerful tool to exercise one's right to freedom of speech and expression, but has been increasingly used for illegal acts. This has led to make the government, just like films and television, to censor social media. While censoring social media content, the possibility of violating civil rights cannot be avoided. Thus, the proper regulation of the social media which does not violate the fundamental rights guaranteed under the Constitution of India is desirable. From the analysis of the IT laws of India, unprecedented power has been given to the government to control the cyberspace. However, even then the agencies are not able to check the misuse of social media. To achieve this balance, the Parliament of India has notified the Information Technology Rules of 2021. The Act provides for the regulation of electronic transactions and cybercrime. The 2021 rules replaced the Information Technology Intermediary Guidelines of 2011. Some of the important features covered in the rules are as follows: due diligence by intermediaries, identification of significant social media intermediaries, mandatory identification of first originator of a message for intermediaries which provides message as a primary service, code of ethics for digital media publisher, grievance redressal mechanism. Thus, the regulation of social media is desirable rather than its censorship. However, the regulation should be in such a way which maintains the rights of the user and also protect that of the victim simultaneously. Thank you and have a nice day.